Hi, this is Chapter 13 lecture video, Plain View, Consent, Vehicle and Administrative Searches. It's similar to Chapter 12, but there's a lot of material. So let's start off with page 381 of your textbook, and you should have already read Chapter 13. You should have your PowerPoint lecture open for Chapter 13 and have your textbook next to you. Look at page 381. Let's look at myths and facts. Myths about the procedures discussed in this chapter. Under the plain view doctrine, an officer can seize anything that is in plain view when a search is conducted. That's a myth. Fact. In order to seize an item under the plain view doctrine, the officer must be legally at the location and have probable cause that the item is either contraband or evidence of a crime. Myth. Evidence officers find while trespassing is not admissible in court. Not true. Fact. Under the open fields doctrine, evidence is admissible even if the officers were trespassing. Searches done near a residential structure do not qualify for the open fields doctrine. Myth. Police must warn individuals of their Fourth Amendment rights before asking for consent to search their personal possessions. Fact. Police are not required to advise anyone of their Fourth Amendment rights. Myth. Only the owner of a building can give valid consent for the police to conduct a search without a warrant. Fact. Anyone with apparent authority over an area can give valid consent for police to conduct a search without a warrant. We'll dive into that more. Myth. Police must obtain a warrant to search a car unless there is an emergency situation. Fact. If police have probable cause to search a car, they can legally conduct the search without obtaining a search warrant. Other exceptions may also apply. Myth. Police are allowed to search a car only if they believe the car is being used for illegal purposes. Fact. There are several exceptions to the warrant requirement that allow police to search cars that are not suspected of being involved in criminal activity. Myth. Warrants that are obtained for administrative purposes must satisfy the same probable cause standards as search warrants. Fact. Administrative warrants can legally be issued if there is a reasonable legislative purpose for the search, as long as the officers are not investigating criminal activity, and we'll dive into that more too. Actually, we'll dive into all of those more. Slide 5, plain view, defined. If the police can see evidence of a crime, they can seize it. There's 3 requirements. Officers are legally at the location. They're there legally. Officers, the object can be seen without a search or without disturbing anything. And there's probable cause that exists to seize that object. Look at page 384 at the bottom, probable cause to seize. The fact that the item was in plain view and the officers were legally present indicates that there has been no unreasonable search. There is a right to seize the item. Arizona versus Hicks stated there must be probable cause. Reasonable suspicion is not enough, however. Top of page 385. Facts must indicate it is more likely than not that the item is evidence of a crime or is contraband. This decision must be made without searching the item for clues, such as serial numbers. So you can't run the serial number to determine if it's evidence. It must be in plain view. This decision, if probable cause exists, the item can be seized on the spot without a warrant. Even when the facts do not establish probable cause, the observation may still be useful. It may provide leads in the investigation. The observation can also be included along with other facts in an affidavit used to obtain a warrant to conduct a full search of the location. So it might be helpful to get that affidavit for the warrant. Slide 6, Coolidge versus New Hampshire. Police were investigating the murder of a teenage girl. The Attorney General of New Hampshire, acting as a justice of the peace, issued a warrant allowing the police to search Coolidge's car. Warrants have to be issued by a neutral judicial official, not prosecutors. The state still sought to admit search based on incident to the arrest, plain view, and automobile exception. Slide 8, plain view, continued. The location does include aerial searches. The observation, it's not a search if items are hidden. It needs not be an accidental discovery. Slide 9, California versus, I don't know how to pronounce that, Cirillo. Mr. Cirillo was growing marijuana in his backyard. but it was invisible from the ground because of fences. Police used planes flying at 1,000 feet to look at his property. Using what they saw, police got a warrant to search his property. The Supreme Court agreed that the search was valid. No need for a warrant if you're flying over the property. Slide 10, Horton versus California. The police officer got a warrant to search for stolen goods. During the search, he did not find goods, but did find weapons in plain view and seized them. The court upheld that seizure under plain view if 3 conditions were met. The officer was there legally, the officer had a lawful right to access the object, and the item seized is immediately apparent as evidence of a crime. Plain view, slide 11, must be in location lawfully. We already said that 3 times, the police officer. There's a consent to enter, or it's public property. Probable cause to seize. You can't seize simply because the police suspects there's a crime. If there's not probable cause, you may still use that discovery to continue in the investigation. And open fields we already discussed on slide 12. Well, police, let's look at that, slide 12. Police may enter property that is not enclosed. Police may trespass on private property. Evidence discovered in open fields may be seized. Slide 13, abandoned property. Owners abandon property when they deny ownership or leave it without the intent to control it later. Property that is abandoned has no expectation of privacy and may be searched and seized without a warrant. Slide 14, consensual searches. Consent is when a party with ownership or control allows access or search of that property. There must be authority to consent. And we will look at the standard for consent. The officer has to ask who can give consent and examine what limits have been placed on the consent, such as time or manner. So let's look at that. Slide 15, consensual searches. Standard for consent must be voluntary, but the police need not inform them that they can decline. So the police don't have to say, you don't have to let us look. They can ask. The police can ask, will you allow us to search your apartment? Consent can be implied by action, so they could just let them in. Consent is invalid if the police lie and say, we have a warrant, and they don't. Then that's invalid. Who can consent? A party with expectation of privacy. If there's 2 parties, either may consent. So let's say it's roommates. One roommate's home and says, yes, you can search the place. A parent may consent for a minor. Now, something about roommates, which I think is covered later. If you have a roommate and you have your own bedroom, you can't consent to allow somebody to search your roommate's bedroom. That's their expectation of privacy. But you can allow them to search common dwelling like the living room and kitchen. Parents may consent for their minor. Children cannot consent to search for the home. Slide 16, who can consent? Parolees and those on probation might be required to consent as a condition of their release. When you go on parole or on probation, oftentimes part of that probation is the police can come and search. It's called a Fourth Amendment waiver. Scope of the search. Whoever consents sets the condition. So that roommate may say, yeah, you can look at the living room, but that's it. They may limit it geographically, by time, or by item. You have 30 minutes. I have to go to work. Or if something's discovered, the scope may widen. Page 389 talks a little bit more about that, about the standards for consent. And page 393, well, actually 390, 391 talks about who can consent, talks more about the roommate, the parent, the child. And 393 at the top discusses how someone can change their mind at the last minute. They can say, okay, you're done, no more. And that's okay. What is found during the search may create probable cause for an additional search. If this is so, this probable cause may be considered by the officers when seeking a search warrant. Anything during the search can be seized if there's probable cause to tie it to a crime. That was on the top of page 393.